Adjournment requests, if any, item number 1 to 5. Item number 5. Item number 6 to 14.
5 minutes. Somebody's there in item number 5. All. Yes.
May it please your lordships. Lordships, we have circulated an adjournment request with regards to item number 10, your lord.
10.
10.
All right. Sometimes in July, August.
12 August.
No, then it is. Yes.
12 August.
Status quo is there, your lord. Continuing with that.
If we are not resigning the order, we are not recalling the order, it remains.
Lordship.
May it please your lordship. With the consent of the other side, I beg to mention item 12 of the daily list, lordship. Lordship, no agenda still has been circulated, but lordship will take in consent of the other side, lordship.
These are merger of schools.
Lordship, the challenge the policy decision of the Shiksha Kshetra, lordship.
A prayer for adjournment has been made on behalf of the respondent state with the consent of the council for the writ petitioner. Let this matter come up for consideration on, give a date sometimes in August.
12 August. Any other requests? For orders, item number 1.
May it please your lordships. Lordship is monitoring this matter with regard to the completion of 4-laning and 2-laning of the Silchar Harangaja road. The respondents were directed to, my lord, place the updated status.
Yes. Yes, Mr.
Well, construction is in progress. Though, as per our affidavit, little bit lagging because due to two railway overbridges coming in between. Actually, anyhow, our today instruction is there by July we will complete everything, my lord.
So, Mr. Das, we close this?
My lord,
Mr. Das, we close this
Yes,
then?
lord.
lordship.
Or one date, since they have assured that it will be completed by July.
Day-to-day monitoring, if it is
I understand,
required,
my
we
lord.
shall. But
I
but
understand.
why? If there is an assurance, you can always have this petition revived if they don't complete.
Yes, that can also be done, my lord. That can also be done. That can also be done, my lord. That liberty, my lord, will kindly.
This case is this construction is pending since when?
Oh,
Since, my
long
lord,
back it is because
2
earlier
decades, 2
but
decades
we-
old, my
2
lord.
decades. Then we should not close this. Now
Exactly.
you will record your statement, Mr. Barwana.
Yes, my statement may be reported as per my instruction, my lord. Actually, I am people because I am also on behalf of instruction
That
only I
means
can submit, my lord.
You're not very sanguine. You're not very clear.
Well, otherwise, lordship, had the my lord, lordship may kind enough to fix after July. Because there is a public interest, I am also involved in that case. Public, I am also public, my lord.
You are part of public, you'll be benefited. But now we are looking at you from the point of view of your stand as regards the National Highway Authority.
Yes, my lord, that is my stand as well as this is our stand.
Mr. C. Barua, you are standing counsel.
NSA.
NHI submits that as per the latest instruction received by him, the 2-lane connectivity road construction would surely be completed by June 2026. Let this matter come up for consideration under the same heading. Again, on, give some time, July or maybe August.
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 Much obliged.
Obliged.
Deeply
August
obliged.
19.
Deeply obliged.
Item number 2.
In this delay condemnation petition, my lord, I have taken steps for as per the earlier order on
Awaiting
21 for my lord. But
Awaiting
services
the-
await, my lord, as per.
the service of notice to the sole respondent, the matter is adjourned to. August last week.
Public.
4th of August. Item 3.
May I please, Your Lordship? I am for the respondent in this case. Lordship, I bring for 2 weeks further time to file my objection against the delay continuation petition.
Mr. So-and-so, who has appeared on behalf of the respondent, so-and-so, seek some time to put in his response affidavit to the prayer made in the application for condonation of delay of how many days? 264 days in preferring the connected appeal.
Yes,
Mr. Stubb. Let such an affidavit be filed positively by the next state, re-notify on sometimes in August.
6th of August. Item 4.
May it please your lordships.
Yes.
Lordship, this is an application for condonation of delay of 29 days in preferring the connected writ appeal against the judgment and order dated 7th February 2026, passed in WPC 6067 of 2019.
All right. We are issuing notice 30 days.
Lordship, there
Do you
is one
accept
humble
notice?
prayer with regard to issuance of
Yes, ma'am.
notice. Notice may only be issued to respondent number 1 to 10 because they are the main respondents in the instant proceedings.
Notice
The
to response
respondent
number-
numbers
1
11
to
to 21 are pro forma respondents.
Correct. Just a minute. So 1 to 10, Mr. Nayak, you accept notice?
Yes, Lord.
If you accept notice, then 34 days delay.
Not the individual municipal boards, Lordship. I'm referring for the government.
For the government, it will be 1 to 6, Lordship.
Yes.
Here is an application seeking condonation of delay of so many days, 30 days in preferring the appeal against the accused judgment and order dated so-and-so, passed and so-and-so. Notice to response number 1 to 6 is accepted by Mr. P. Nayak, Learned Additional Advocate General for the state of Assam. So let notice be issued to response number 7 to 10 on steps being taken by the applicant within a period of 2 weeks, both modes returnable on so-and-so date, August 1st week.
4th of August.
Deeply obliged, Lordship.
Item 5.
Adjournment slip. For the respondents to pay money.
Adjournment slip has been circulated. You have consented.
I have considered.
You have consented. All right. Adjournment slip has been circulated with the consent of the.
19.8. Item 6.
May it please your lordship. This is a writ appeal preferred by the state agency lordships, server 6 revision. Lordship, in this composite judgment, one writ petition judgment is in our favor where the fund is from the state government and when it is from the central government, the judgment is against us. There are a lot of anomalies how it is happening if every school will have to file.
Now there will be no uniformity otherwise.
There will be no uniformity and they do not have the wherewithals and the expertise to do e-procurement.
Correct. We are not. We are tentatively not in agreement with the order.
Lordship.
But let us see what have you done in the meanwhile. This was
That's additional affidavit lordship allows, I can file, because in the meantime we have done and there is what they have done. They have reduced the amount value. So that e-procurement they can evade.
No,
So
just-
as a whole, the school is suffering.
You file that affidavit.
Yes,
In
lordship.
the meantime, who is to be noticed?
Respondent number 1, lordship. Hemanta Kormokar.
We will ask for dusty service of notice.
Lordship.
We must decide this. I mean, this was no reason for cancellation of the
Only
tender.
one clause says the schools
correct, yes.
may go through the SMC. That may word has been converted into shall.
Cannot be mandated.
And there are a lot of conflicts in the whole policy.
Cannot be mandated. Anyway,
Lordship.
we have heard the letter advocate general for the appellant state, for the appellant, namely Samagra Siksha, which is the Samagra Siksha from Assam, which is the state level implementing agency for education related schemes, including infrastructure in schools. It appeared that on 1st of November 2022, the appellant floated a tender to GEM portal for supply of 31,730 sets of dual desks and benches to be delivered to 1443 number of schools across 30 districts of Assam, with the estimated tender value of approximately 32 crores. One of the tender requirements was that the bidder should have an average annual turnover of 9.52 crores in the last 3 financial years, namely financial year 2019-20, 2020-21, and 2021-22. This tender was questioned by the respondent, a furniture manufacturer registered under the MSME scheme, on the ground that many government guidelines with regard to floating of tenders by Samagra Shiksha was bypassed. The issue raised by the respondent before the learned single judge was that in view of clause 7.14.2 bracket Roman 2 in bracket Roman 3. What did I say? It was mandatory to procure furniture for upper primary and secondary school, whether or not it was mandatory for procurement of furniture for upper primary and secondary school through
State, district or SMC. Is that
through individual school management committees or subdivisional management committees. And whether any derogation from this requirement would be violation of the general financial rules of 2017 regarding tender procedures and the thresholds. The learned single judge, by the due judgment, has held that since the procurement in question was under a centrally sponsored scheme, therefore the manual of financial management and procurement was applicable. So in that context, it was held that clause 7.14.2 bracket 2 Roman 3 of the manual of financial management and procurement is mandatory. It specifically requires that procurement of furniture for upper primary school should be handled by school management committee or equivalent bodies, but not through centralized tender by the state agents. The opinion of the learned single judge was that issuance of one composite tender for the entire state violated this mandatory provision. The learned advocate general, by assailing the aforesaid judgment, has submitted that the requirement could not have been held, that the requirement under clause so and so could not have been held to be mandatory, and that the learned single judge did not appreciate the perspective of the state, perspective of the appellant, that in such cases, bulk procurement was necessary for not only the quality, but uniformity in supply of furniture in all schools. He has therefore submitted that with the impugned judgment, cancelling / setting aside the notice inviting tender dated 1/11/2022, the procurement process for schools have been halted, and the education system has suffered thereby. There are further anomalies there are further consequent anomalies of the judgment which the learned advocate general submits would be brought on record by way of an additional affidavit. Let notice be issued to respondent number 1. Let notice be issued to the sole respondent on steps being taken by the appellant within a period of within a period of 2 weeks, within a period of 1 week, both modes returnable on so and so day. The respondent shall be served thusly as well.
Paper publication we also allow, because in the delay petition, he did not appear and we have to give paper.
For the reason of the urgency of the matter, we also permit paper publication, a substituted service by paper publication.
Newspaper.
2 newspapers, 3 newspapers having good circulation in the area.
Yes.
With one of the newspaper publication, one English daily and 2 daily in Assamese.
Assamese and 1 Bengali also.
Assamese, Bengali, and
2
English.
vernaculars and English.
2 vernaculars.
Deeply obliged.
We fix it in August.
10th August.
May I pray for suspension of this order?
In the meantime, suspension
Operation of this.
or suspension of operation would be all right, but then in the meantime, if you issue tenders, then that will not be good. So we can prepone the date.
Lordship, in the month of July.
Correct, July.
Yes.
We understand the urgency of it.
Lordship, highly obliged. Lordship.
13th.
We can keep it in the last week of June also.
Last week of June will be very nice, Lordship.
Keep it on the 5th of June.
Lordship, highly obliged.
We would have stayed the operation of the judgment, but then that would have decide that way we decide the appeal totally.
That is also created by, suppose we issue a tender paper and ultimately it is dismissed. Then we'll be in two foots on 2 boats.
The stay would amount to, that will not be appropriate. We will give you an early date.
No difficulty.
Let him come.
In June, latest on 25th June, Lordship, we will argue the matter on this. Highly
No,
obliged.
that way.
Item 7.
That current process has been altered. That it cannot be the.
It has gone topsy-turvy.
Ah.
I would rather use that word. Highly obliged.
Item 7.
And open up lot of floodgates for corruption.
No, local schools, they will ask their own what kind of supply, what. No, we are
What
not
they,
for that.
what they are doing, they are taking ports from trees.
No, not for that. I am surprised with that bulky adjustment.
Now those are the practices now going on after this judgment. Highly obliged.
We are challenging the order caused by the honorable cap. So here, which of the delinquent employee. Here we expect a deposit from.
We would have straightway interfered, but for the fact that the man is dead.
When is that?
And now the wife has stepped into his shoes and she will not get pension otherwise. On principle, we understand. Now, high courts are loath in interfering with the quantum of punishment. The tribunal doing it on what ground we are not aware of. What we do is we issue notice and we are not staying. We are not staying the operation of the imputed judgment only for the reason that she is a widow. And by virtue of the order of the cat, are you paying a pension?
No, Lordship.
Ah. That is a ground which is weighing heavily with us.
No.
Punishment should not be disproportionate. Now, if the cat cannot do, we will do it. So we issue notice, just that.
So let us, because hot that Lordship, till then, we stay.
Obviously. No, then you have understood the reason. On
Yes, yes,
principle,
Lordship,
we are
absolutely.
agreeable. On principle, we are agreeable.
Lalit Cat also did the same.
The tribunal actually, looked at the whole picture. There were smaller offenses. He was taking the money and he was not giving it to the bank. And then ultimately he returned it. Now that this is a good ground for dismissal. And he died midway. Money has been returned. All money has been returned.
All money has been returned, but the conduct has been for 3 times.
Pension, start with that. Let us issue notice and let us conclude it. We will give our own reasons. Individual cases, this will not be cited as precedent. But we can't stop the supply line of, lifeline of people. Law is meant to benefit people, not to trouble them. And then money has been received, so this could be disproportionate. We'll see. A disciplinary proceeding was initiated against late Ajit Chandra Kalita, husband of the respondent, who, while serving as postal assistant under the Department of Posts, was alleged to have misappropriated public funds by collecting money from the depositors, but failing to credit the same in the government treasury, government account. There were several instances when such lapses were noticed. He had been put to a departmental proceeding where the charges were found to be proved. Based on the inquiry findings, the disciplinary authority initially imposed a penalty of reduction of pay by one stage for 2 years, with cumulative effect on 15/5/2019. However, upon review under Rule 29(1) bracket Roman 5 of the CCS bracket CCA rules, the revisional authority enhanced the penalty to dismissal from service by order dated 31/12/2019, considering the gravity of the misconduct. The employee approached the tribunal, Gauhati, seeking quashing of the inquiry report, the disciplinary order, and the dismissal order, and prayed for reinstatement and refund of 6,34,000. During the pendency of the proceedings before the tribunal, the employee died, and his wife / respondent was substituted in its place. The tribunal, who had impugned order dated 7/11/2025, partly allowed the application by modifying the penalty of dismissal to compulsory retirement and directed release of consequential benefits to the legal heirs within 3 months. This has been questioned by the petitioner / Union of India and others, primarily on the ground of the tribunal having exceeded its jurisdiction by interfering with the penalty imposed by the competent authority. there was nothing on record for the tribunal to hold. There was nothing on record to indicate that the disciplinary proceedings were not conducted fairly, or that the principles of natural justice were not complied with. Under such situation, the punishment imposed on the employee could not have been interfered with without holding that the dismissal was disproportionate and shocking to the conscience. With sufficient reasons, the punishment initially imposed upon the employee was enhanced. The misconduct involved was misappropriation of public money and grave breach of trust. The argument on behalf of the petitioner today is that regardless of the subsequent refund of the money which was not credited in the bank, in the government account, the seriousness of the misconduct did not stand mitigated. The other argument raised on behalf of the petitioner is that with the judgment, with the impugned judgment, the two other original applications, namely OA number 67 and 68 of 2020 respectively, arising from the other cases of misconduct / misappropriation, were rendered infructuous in view of common judgment in OA number 69 of 2020. The fallacy in the judgment, it has been argued, is of treating all instances collectively, all instances of misappropriation collectively. Let notice be issued to the respondent on steps being taken by the petitioners within a period of 2 weeks, both modes returnable mid-August.
If I pray Lordship, a short date may be given and set out.
We'll deal with this argument.
19 August.
We will deal with the argument which you have raised or which you would have raised or which you would raise at that time. We'll deal with the argument, but compulsory retirement, I mean, how do we stop pension? Well, let us hear. Otherwise also you're not giving a pension. And she being a widow, she has not even come for implementation of the order. So therefore, we are not in a hurry, and you should also not be in a hurry. It will depend on what we decide of that.
Item 8.
Yes, Mr. Khatniar.
Yes, madam. In the meantime, we'll face so-called notice of issue to the applicant.
Just a minute, let us go through our earlier orders. You know, department. Did you issue the regular department?
Yes, madam.
You have.
Yes, madam.
And what is the result?
Recently, madam, we have issued a show cause notice.
Recently?
Recently, we have issued
Probably
a,
because the court asked you to.
Yes, Your Worship.
But
Yes,
liberty was given to you by the single judge.
yes, madam.
You chose not to.
No.
And still you were keeping the person away from the post to which he is entitled, he or she.
See, Your Worship.
The earlier order, madam, that was withdrawn on
Complete
29 for
proceedings.
2026.
Complete the proceedings and then come back to us.
Yes, madam.
Yesterday.
No, in that case, I think we must close this petition now. We can't put them under any, under threat that you must do something. No. They have initiated a proceeding and let you not be. Why do you want to be the in charge? When because of you, so many persons faced 73 students. So did they all recover?
Lots of recovery, Your Worship.
They all recovered.
All recovery, Your Worship. Lordship, that more importantly, Lordship, who holding the post of in charge of the headmaster is a tutor, Your Lordship. It's a settled law, Your Lordship. Tutor cannot be hold the post of in charge, Your Lordship.
You are the senior most.
Yes, Lord.
And the number one, and the one who is serving under you, she has been made in charge.
Yes,
She has been made in charge.
This is a scenario of our Assam, Your Lordship. More than the 150 students, we are running the school with teachers, Your Lord.
That's all right, but then if you take up, why do you want to take up the responsibility then of feeding them?
Lordship.
Let it be done by somebody else.
No, Lordship, with the help of that helpers, Lordship, as per the Lordship guidelines.
No, that's something which is uncondonable. Of course, you were not subjected to a proper departmental proceeding. I don't know who suggested Mr. Khatniar to stop it midway and then saddle you with a punishment, which can be given only after the procedure is followed. So that liberty was given, that liberty they have exercised. And in the meantime, I don't think you should be allowed to head. We close it.
How can you allow tutor to run a school? Tutor is not even a teacher.
Yes, yes, madam. That is there, madam. That is there, madam. That is there, madam. Tutor is. In fact, madam, in lower primary school, there is no concept of headmaster also. Only an in charge.
Education department is in need of total revamp. That is not done. That you're Mr. Gogoi.
Lordship.
But that Mr. Gogoi does not have a great case here. That's different. That's the way you are handling it is also bad.
Lordship.
When will you conclude the proceedings?
Within 2 months.
So, Mr. Gogoi, otherwise we are inclined to close this petition.
Lordship.
But then we keep it. In case they don't find it guilty, you come and withdraw this.
Lordship.
In that case, they will restore you to your position.
Lordship.
We don't want you to be restored to the position for one fault in your life, where 73 children, they fell ill. And it was found that you were negligent. Your cooks were negligent. Who is to bear the brunt? The in charge. Huh? I think we close it to saying that within 2 months.
Yes, madam.
Your Lordship, Lordship may come to the question number 36, Your Lordship. But here, Lordship, the act has clear. I am not responsible for that incident, Your Lordship.
The appellant was, as we have heard, I will try and protect you to that extent. Just that. We have heard Mr. T. Gogoi, learned advocate for the appellant, and Mr. N.J. Khatniar, learned standing counsel, Department of Education. The appellant was removed from the position of in charge as head teacher, as she was prima facie held responsible, along with the cooks and helpers, in serving contaminated food under the midday scheme, leading to 73 students suffering from food poisoning. The appellant was suspended immediately, and a minor penalty was imposed upon her. Along with that, she was removed from the charge of head teacher. This decision of the respondents was questioned by the appellant before the learned single judge. On the sole ground that even a minor punishment like stoppage of one implement without cumulative effect and removing her from the position of in charge teacher what did I say? Could not have been settled on her without the procedure prescribed under Rule 9 of the Assam Service Discipline and Appeal Rules 1964. The learned single judge set aside the decision of the authority and also ratified the revocation of suspension of the appellant simultaneously. However, liberty was granted to the disciplinary authority to proceed against the appellant, if so desired, by instituting a regular departmental proceeding against her, but only after following the provisions of the rules of 1964. It was also observed by the learned single judge that till such time that the proceedings would be initiated and concluded, it would not be obligatory for the respondents to give the charge of head teacher to the appellant. Which decision ought to turn on the outcome of the departmental proceeding if initiated. Today, Mr. Khatniar, Standing Council Education Department, has informed this court that the disciplinary proceeding has already been initiated against the respondent. He has further submitted that in all its probability, the proceedings shall be concluded within a period of 2 months. The department shall review after the disposal of the disciplinary proceeding whether to restore the appellant to the position of in charge principal, as the person who has been made in charge is a tutor who is not authorized to run the school. With the aforementioned observation, we close this appeal.
Obligers. Item 9.
Please, sir. Unless I am sorry for the inconvenience to your lordship as well as my young senior friend.
This
I mean,
is the right formulation. He has an objection which I can see is
My lord.
shaking his head.
Because
He has come for this case only.
I tried circulating one adjournment request, but since consent was not given by the Leonard State, Nagaland, so.
But you were in a hurry on the
My
last
lord.
picture.
No, my lord, because the.
Weren't you in a hurry? We
Yes.
understand your leader in this matter, Mr. Chaudhary, is, I mean, every case is being adjourned because he's not here. But then what do we tell to them? They have
My
come
lord.
from Delhi, both of them.
My lord, the problem was that we had prepared.
They could have appeared online also with the new rules here, but they have chosen to come because the matter is important. How do we ask them to go back to Delhi without anything? So you argue, they will also argue, we'll continue it for some time.
The only difficulty is that, my lord, we have prepared the affidavit, but we need a vetting from senior counsel. Since he was out of station, my lord, that is why he couldn't file it. Only 1 week's time, my lord. Any date, your lord. No.
Now, if we grant time, it will be subject to the choice of Mr. Balgopal.
My lord, I agree with you.
I know as far as this case is concerned, I respectfully submit that going on for some time.
Mr. Balgopal, you'll have to be slightly louder. Probably the machine is not working.
That's been
Is
going
it
on
working?
quite some time now.
Yes.
Now, we have filed a detailed counter. In the petition,
What happened?
we have filed a counter affidavit
In that PIL.
in the period,
Yes.
which is on record. Now, all these three PILs are not maintainable in law, technically also, for the reason they have challenged the virus constitutional validity or the sanctity of certain laws passed by the Nagaland. A division bench of this honorable court in the oil exploration case, which I had appeared, that is as to who has the control of the oil resources of the state of Nagaland, whether it is the Union of India or whether it is the state of Nagaland in terms of 371A. That question was partly decided to this extent that the validity of the laws cannot be tried in a PLA. There are Supreme Court judgments on that also, which I shall bring up. Secondly, my lord, this petitioner Kiran Pera, he has not disclosed one important fact, that he belongs to the Kachari tribe himself. And according to our notifications as far as PA litigations are concerned, you have to give a declaration that you don't have any personal interest. He has given that declaration. And all those things that he has not suppressed, in fact, he is filed in affidavit. In a similar case like this, when the challenge to
Mr. Balgopal, let us admit that, notwithstanding the fact that the petitioner is a Kachari, but personal interest would lie only when he would be required to take that permit. If that is not the case, then any person of any nationality.
No, that with great respect is slightly different. There are cases where
No, you can argue on the merits of the case.
I'll argue on merits.
The maintainability would be difficult on that ground.
As far as the preliminary objections are concerned, that
Yes,
has
yes,
to be,
we acknowledge it.
that has to be looked into because it's not maintainable. There are cases where such
Correct,
cases
correct,
have been
correct.
dismissed with exemplary
A
cause.
strong possibility of
Yeah.
there being a vested interest.
Yeah.
Strong possibility, that's all.
No, no,
But
it's-
that affidavit, here, as he filed
when,
that
when
affidavit,
a petitioner suppresses the fact, it's a clear case of suppression, not how it affects him. He files an affidavit before this court saying that I got nothing to do with this. He himself is a Kachari and I have given so many paragraphs.
being a Kachari does not make him a person with interest.
Yes.
Whose interest?
Yeah. And
Mr. Balgopal, we are saying something else. Being a Kachari does not disentitle him to file this petition. Unless you're in a position to say that no, he wants, he does not want to go for that inner line permit. He is being prevented and therefore he has filed this case in personal interest.
as far as this case is concerned,
Suppose somebody says that I hail from this area. We are just taking the logic to this. I mean, maintainability is would be slightly difficult. You have every authority to raise that issue. We will answer that. Question is that suppose somebody says that the condition, say, open manholes in the city of Gauhati, which is creating problem. Now, can it be questioned that well, there is no public interest because you are a resident of Gauhati?
that's a completely distinct issue. As far as this case is concerned, he's a Kachari. He files the affidavit before the court.
No, your ground that the constitutionality of a rule cannot be questioned in a PIL.
Yeah.
That is something else. If you're questioning his locus on the ground that there would be some vested interest in the matter, therefore he cannot be a public spirited. He cannot be that.
The important point is whether an affidavit filed before this court, my lord, one is entitled. My lord, he has to say according to our rules.
No, we are aware of that. We do public interest every day. We are aware of that.
Yeah.
You have a very strong case on merits. I think you argue on that.
Apart from merits, then if it's on merits, let him start
Yes,
with
yes.
his petition.
Yes, yes.
My lord,
Maintainability, Mr. Balgopal, you have a right to argue unless you are coming up with a different plea that this constitutionality of any legislation cannot be questioned in a public interest litigation, then that is debatable. Because we are aware of some decisions of bench of equal strength, I mean, same strength,
They are on different issues.
maybe on a different issue,
Different,
but then,
here, he has to file an affidavit. And he
yes,
also to state according to our rule,
every,
on whose behalf he is appearing. That's specific.
that is
Our
not fine.
rules have to be observed. Anyway, let him start.
Mr. Balgopal, the difficulty is that he's being overshadowed and he's frightened with your domineering presence. His senior is not here.
I can't say anything. But the fact is,
But
madam,
can we, this is
I've been appearing on directions of the court only,
correct.
not otherwise. That's why wherever
No.
possible, I've tried to follow.
Mr. What is your name?
K. Mohammed.
Mr. Mohammed.
Yes, my lord.
Mr. Mohammed, but there is another advocate. Mr. Santanu Thakur was also.
My lord, that is in respect of item number 14.
If he's ready, let him argue. Other matter will be argued because we don't want to send them to Delhi again without doing anything. So far as the court is concerned, we are not opposed to for the reason that you have. I mean, we understand the difficulty of a junior lawyer. We do understand the difficulties of a junior lawyer. We have crossed that stage. Correct, but we can't ignore the presence of Mr. Balgopal for the third time in this matter. And on the last two occasions also, the matters were adjourned,
My lord,
much to his chagrin, much to his dislike, because he comes prepared. Now, why should he go back without, unburdening his mind with all this?
my lord, if I just point out one thing, my lord, as per your lordship's order 23.3, your lordship fixed the timeline that the state of Nagaland will file the affidavit on 14/5 on 24/4/2025 and directed us to file a reply. In the meantime, your lordship fixed it on 14/5/2026 so that the matter can be taken up for final disposal. They file it on 11/5. So that is why the delay.
Can that be a ground? If that is your ground, then that is
My
not.
lord, just I'm pointing it out. I'm just pointing it out. my lord.
Mr. Balgopal, one more occasion. Now the choice of date shall be you. We can't, the practice of this court is that we normally, in cases of this.
I won't come in the way of my lord views. I will never come in the way. But the fact is, my lord,
This is more like a
this is
senior.
like a big game.
My experience that
Big game, file a petition, disappear,
it would be,
and then give a big lecture in the court. Let him know by the concept. So, if your lordship says, as you said, that I feel proper on my side.
place him in a position of.
No, I will never do that. That I will never do.
The young advocate will not,
It's going on for.
will not be able to match you otherwise.
No, no, not that. It's not a question of matching. It's a question of.
No, no, we understand. Thrice, I remember, thrice.
I have nothing against my learned friend. But when I believe he has gone abroad or something, he was aware of it the last day. It's not that suddenly we have summoned.
Let's not put him to any
No,
embarrassment.
not at all. I'm not talking.
So young advocates need to be protected.
I'm not on that way at all.
Correct.
When your lordship
Correct.
says that.
So this time the choice of date shall be yours.
And it's a bit.
Have you any option, Mr. Mahmood? Let him take a call about the choice.
Keep it next Friday or Thursday.
Correct?
Thursday.
Next Friday
Right.
on the ground of absence. Any problem with that?
No, no. We have our difficulties, but that's not an issue.
All right. See, I'm being doubly positive that next time you don't return without arguing the case. That is the only reason.
I wouldn't have argued today also because he was appearing, but I was only expressing my problem.
On account of absence of Mr. K. Chaudhary, learned senior advocate, who has to address this court in the matter, let these cases be listed on 5th of June. 5th of June. No, we are not writing, but no further adjournment on any ground.
He may also give me a copy of the affidavit which he has got.
I'll give him.
Today itself he'll give before I leave. You said it's ready. He
No,
just
it's
mentioned
ready. I have to
about
get it
ready
from senior
for
counsel.
signature. Now he says it's not ready.
My lord is ready.
No, Mr. Balgopal, it will be dangerous for him. It has not been vetted by
Yes,
senior.
exactly. That is what I said.
Then be two kinds of affidavits.
Okay.
But
File before Friday.
My lord.
file before
I'll-
Friday.
I'll file
And
before.
ensure that you transmit to them, not the local council, transmit to them by mail or something.
My lord, in advance, by Wednesday, I'll give you the extra copy.
By Tuesday, because the case is on Friday.
My lord.
On-
This time even the journey from Delhi was very tiring because there were heavy rains. We were in the aircraft for 2-3 hours.
No, and but now you never know what will happen from 1st of June.
And then we went via Jaipur.
Acha, like this.
Yeah, we went on all over the place. And when he was landing, he was saying that our fuel is very limited. We reached the Nagaland house at 2 o'clock in the morning.
You have understood now?
My lord.
No adjournment.
My lord. Apply.
Item 11.
Yes, Mr.
My lord, here is that grazing reserve land, why it is not permissible. It was de-reserved, given for private use. Within 3 years, again, those private person sold it to somebody.
Please for respond number 6 and 7.
One affidavit has come from the government by which says they have admitted that now the industry is nothing is there. Some shops and some petrol pumps are there in the grazing reserve.
No, but how could it be sold to them? So who are those owners of the shops?
I have, my lord, I have.
Lordship, I am appearing for respondent numbers 5 and 8 to 11. So 5 was the industry to whom it was sold,
Yes.
and 8 to 11 are some of the people to whom respondent number 5 has sold the property.
So what is your response to this? Now, how could you do
Lordship,
that?
Lordship, if your
Have you
Lordship
filed your
kindly,
affidavit?
yes,
Have you
Lordship,
filed-
we have. Yes, Lordship, I have filed my affidavit.
No copy was.
Copy has
The other
already
side,
been
the
served.
other side lawyer does not have the, does not
Lordship, we cannot file an affidavit without serving a copy. The copy was served in
Government has
advance.
also not received. I have also not received.
We understand that, Ms. Agrawal. You can't file it without, but they have not received it. Do you have any local counsel here? Are you
Lordship, I
addressing-
am in Gauhati itself, but since the rule has come up that Mondays and Fridays, preferably VC, that is the only reason why I'm appearing through VC
You
today.
have them served. We'll hear it on some other date.
Lordship.
Filed on 13/2/2026.
And who has signed it?
An affidavit filed on 12/5 by the respondent number 3. one affidavit filed by respondent number 3 on 12/5/2023.
No, no, 5 and 8 to 11.
Five,
5
eight,
is the company which was given that land
No, no.
and company
Sold it.
sold it off.
It's 71.
Anyway, you serve it, we'll hear you on the next date. Next date,
Lordship.
this is an urgent matter for the reason that you can't we will see what authority you had to, to sell it. Now, unless it would have been de-reserved, your entitlement was wrong. And even if you were given, you could not have sold it. And now,
Lordship, this is the second round of litigation in my humble
now we are
submission.
not concerned with second or third round. We are on the basic principle. So we will see you. We need to hear you. Without hearing you, we shall
Lordship.
not.
Lordship.
You serve them extra copy. Even there is some miscommunication, it appears.
I will, Lordship. No
So we
difficulty
are
in that.
keeping this matter in the next week.
Lordship, any date apart from 2nd and 4th.
No,
3
no,
or 5.
not in the first week of June. We'll keep it in the third week of June. Next second,
Lordship.
third. Let it come on a Thursday, 18th. 18th of June.
18. Yes, Lordship. No difficulty.
Yes, Miss P. Agrawal, learned advocate, who has appeared on behalf of response number 5 and 8 to 11, submits that counter affidavit on their behalf has already been filed. The learned advocate for this, neither the learned advocate for the state nor for the petitioner have received a copy of the same. There appears to be some communication gap. Let Ms. Agrawal serve the copies of the reply affidavit to the learned counsel for the petitioner as also the state on or before before the next date. Let this matter come up for consideration on 18th of June.
Obliged.
Deeply obliged, Lordship.
We'll come back after 5 minutes.
Supplemental.
We come back in 5 minutes.
Item 15.
User lodge. We have received an affidavit now.
Louder.
We have received an affidavit now filed with the respondents. We are sitting some time to file our reply.
What do you want to respond to this?
Actually, my lord, senior counsel is not available, my lord. His name is there. The name of so I have to speak
See
to
that.
this person.
What response would you give? Any difficulty? No. As this public interest dumping ground, what have you done about it?
Lordship, our affidavit is on record, Lordship. Actually, Mr. Dina is appearing in this matter, Lordship.
So both of you are sailing on the same boat. Huh? As jointly prayed for this matter on to keep it in the third week of June. Again, 18th of June.
Item 17, supplementary list.
Lordship, our affidavit is on record. Our affidavit is on record. Last time it was not on record.
Today it's on record. Yes.
So if your Lordship refers to affidavit.
No, let him argue first. No? Let him argue. Has he finished his argument?
No.
Now then,
I'm just letting him know.
you take a seat. Yes, Mr. Salim.
May please, Lordship.
Can you give us 1 minute?
That case, my lord, in fact, that was filed without the judgment. Now this is by way of, my lord, additional affidavit. It starts from page 137 now.
How has that issue been dealt with by the municipality? Which affidavit? It's additional affidavit, right?
It starts from page, my lord, 157. The judgment starts from page 141 now.
I think that was in the IA.
My lord, there's actually an additional affidavit, my lord. This is not on the expert. That is on record now. 143.
Should have been tagged with that report, no? What is their affidavit? Yes, Mr. Talga.
My lord, here, basically my submission was before the honorable single judge, that the order passed by the authorities, well, firstly it's a stimulus.
Can you place that order at page 89?
Yes, ma'am. Page 89, my lord. This is the order of 2625. My lord, to understand the order,
Yes,
my lord, to understand the order.
this is stigmatic.
Yes.
There's no difficulty.
Yes.
But they have given you another communication. It says that it is an organizational interest. An assessment of your performance is part of the decision making. Now, there is a very fine line of distinction. We need not quote from various judgments of Gritko and Suresh Kumar. The question is this, that if you are under a contractual agreement and that there is no other agreement to put you on board till the time your contract is terminated, that also would be an extension of the agreement. There is nothing of that kind which you have stated in your petition, in your memo of appeal, which is incorrect.
My lord,
You have talked about some agreement which allows you your stay
Yeah.
on board
Yeah.
as a finance manager
Yes.
till 2026.
no, not till 2026. I'm not saying that. What I'm saying,
It was transitioned from Assam Skill Development Project to Assam Skill University. That's all.
no, my lord, what I'm trying to say, it was up to 21st March agreement. Thereafter, I continued. And the interim order was passed, my lord, in the month of June. So essentially, they allowed me to continue beyond the, my lord, contractual period.
Nothing. But does that give you a right, a protection that you cannot? I mean, that's a matter of, see, no matter how much we may employ various phrases and words and, lexicographical, what do I say? Calisthenics. But the fact remains that for coming to a conclusion that you're not required, there has to be some fact finding, and then very well, contract is over, you go back home or you go anywhere, we don't require you. That authority should be given to the organization or not. The only thing is that it should not be stigmatic. If it is a contractual appointment, what to do? Now, what is the foundation? What is the meaning? All this goes in thin air. Once they say that it is an organizational interest, we just do not extend it. Can we force them to extend it? That's the only question. He appears to be a good officer. The allegation against him is incorrect. Now, the annual expenditure amount, assessment, whatever he had to give, that could not have been given out of your own imagination. Correct. It was consulted only after the technical assistant or technical consultant it was given. But somehow the other, your performance did not please them. But the difficulty is that you are under contractual employment. You are not a government servant against whom nothing is available. What do we do? Both sides, you are aware of the arguments. They say that gone are the days when, it will only depend on the sweet will of the employer. It is amenable to judicial scrutiny. And in next breath, we only say that we can't sit as administrators with superpowers sitting on the armchair and say that, no, this termination is bad. Can we do that? Now, both things can't go together. But here, if they specify that they have nothing against you, it's an organizational interest, then it is no part of our business to lift the wheel out of this known extension of termination.
They does not say that. This is my submission, my lord. This is my first limb of argument. My second limb of argument would be, there is one case, my lord, which I have cited before the Honorable Single Judge, Abdul Qadir's case, my lord, that once you are appointed under the scheme, your employment would be co-terminus with the scheme.
No, but why do you say that he was not, you issued this letter on 8/5/2026? Yes, right, and the earlier letter was issued, which is at page 89, that's what's the issue? 26/25. Then for this period, he has not worked.
He was
Nothing.
on 30th of June. In terms of that 26, page 89. Please consider the second last paragraph, Your Worship. And the third last paragraph.
Mr. Talukdar, we can't help you.
No, Doctor, can you allow me?
Please,
Yes, yes.
please, please, we are not stopping you from asking.
My lord,
We were trying to find out some way of giving you a lease of life.
correct. No, in fact, the impugn order, your lordship has, my lord, agreed with me that it is a stigmatic order.
Correct.
Now, my lord, this apparent, my lord, from the order, an inquiry was conducted, which I am not part of it. And secondly, my lord, they say that due to want of diligence, my lord.
Mr. Talukdar, I'm stopping you. I'm so sorry. I'm stopping you midway. Because there is no use of, entering into any argument on that score. Suppose, as you said, we rightly agreed with you. We agreed with you. We agree with you. We are on the same page that this order dated 2nd of June 2025 is stigmatic. Yes, come on.
Correct.
So we set aside that order.
Yes.
Correct. Then we tell them that now you pass a fresh order. We take this order as the fresh order.
My lord, with all
We
this,
take this as a fresh order.
my lord,
Where do we go? I mean, what is the passage to us? Tell us. And now we are not asking you to concede. We
No.
are not asking you to
No,
concede.
this order, my lord, fresh order which is passed. Your lordship will see, my lord, this is nothing.
I think that the two words should not have been there. Mr. Bura should have advised his client not to say all this. This is not in continuation. Nothing.
Correct, my lord.
Recalling that order, this is this.
I'm on that, my lord. Because the earlier order, my lord, it is stands, my lord. By this clarificatory order,
You clarify this.
the earlier order stands, number one.
It shall not be taken to be stigmatic in any way. Your term has concluded, they have not renewed it. Finished. Can we get into, do we have the passage to get into it now?
My lord, one submission, my lord, which I have made before the Honorable Single Judge, not considered. There is one judgment of this Honorable Supreme Court, Abdul Qadir's case, which went from this Honorable Court, saying that when the, my lord, appointment is on contractual basis, normally it should be coterminous, my lord, with the scheme, when it is under a scheme, my lord. Now, my appointment is under a scheme pursuant to a regular selection. Now, your lordship will see, my lord, Abdul Qadir's case has not been considered and they want to replace me by way of another contractual appointee. This is not a regular selection which they have done. So until, my lord, I am terminated on disciplinary ground, being a, my lord, having been appointed.
I think that's an argument which takes you nowhere. If you're referring to Piara Singh, that is not applicable in cases of these contractual appointees. That is contractual appointees against a substantive post, and one contractual employee cannot be removed for substituting him with another contractual employee. But the position, the post must be substantive, vacant, government post. Now, this is a project. You're in the university. Where is your case that it is against a sanctioned vacant post that you're working, that a contractual employee, even though you are on contract, you can't be replaced by another contractual employee?
My lord, I am relying on Abdul Qadir's case, para 17, your lordship.
Veterinary department.
My lord?
Veterinary.
No. PIF scheme, home department, my lord. Para 17.
That scheme itself, I think, so far I recall, it was that the appointment should be coterminous with the project. That was
Coterminous with the
mandated in
scheme.
itself.
Yes, that is what I am relying on here, my lord.
Something very different, no?
Para 17, my lord, me kindly see it. That was a scheme under prevention of infiltration scheme, my lord. Those
My lord, retired employees, armed personnel, paramilitary forces, they were appointed.
No purpose. This is in that specific, it doesn't lay down any.
My lord, here, my lord, I am appointed under a scheme. Scheme is continuing. So, my lord, pursuant to regular selection, my lord. So I'm not saying, my lord, they cannot remove me. On a disciplinary ground, my lord, they can remove me.
These are ad hoc. These are not even ad hoc. This is yours is contractual.
My lord.
What is ad hoc? It's contractual. With a term, fixed term. No further extension. In fact, they were not inclined. See, your position, your services were being taken by now the Assam Skill Invest. Initially, it was some project. Now, if you press on that, your appointment should have been over with that position. The scheme having gone. Now they have
Implementing agency, my lord, is transferred. My lord, otherwise, my appointment is still.
Can we go beyond it? Which law authorizes us to ask an employer to continue with the employment of a contractual employee after the termination of the contract? What do we do? We can only ensure that your exit is not ignominious. Your exit is respectable. That's all.
Yes.
We will further specify. Going beyond our mandate, we'll say that let it not be taken as stigmatic. If you agree for it, close it in no time. If you want us to discuss everything that you did not supply, you did not give that assessment in a proper way, therefore you were removed. Then you filed a case, and thereafter they have recalled. All this brings it alive that your competence was questioned. You want to do that? Or do we say that now with the intention of the employer not to continue with the contractual agreement without there being any stigma? Mr. Talukdar does not press this appeal. Finished. Or you want us to deal with everything that you have said. This is what the learned single judge has said. Then perhaps any employer would not like to employ you for the reason that this is the background fact and we can't do anything about it.
Malad, I would like to press it to the extent that the impugn order, Malad, should be set aside. Because this clarificatory order, Malad, it takes me nowhere. Because this, my lord, in fact, it validates the earlier.
They have done a wrong thing.
Earlier order has been valid, my lord.
Say something about it.
And my lord, honorable single judge, my lord, in paragraph.
Now, this letter at 144, the difficulty is they don't understand when they write.
And my lord, with all respect, honorable single judge in para 19, 23 and 24
Then Mr.
proceeded to hold, my lord, it is not stigmatic.
In continuance of our earlier letter.
Your Lordship, on last.
What was the necessity of this? This is an independent exercise of power.
What actually went from your Lordship on the last occasion?
You withdraw the earlier one.
And ask him to go after expiry of the contract, matter ends here.
And they say in organizational interest. So my presence is detrimental to them. It is stigmatic here also, my lord.
Your Lordship.
In organizational interest, second parameter.
This is simply asking that your contract period is over, you will not get anything from this period.
Earlier order should go, my lord.
Where is that?
Yes, second paragraph. Please note, although this clarificatory letter is being issued, no, the second paragraph, upon completion of your contract period, it was decided in organizational interest. So my presence is detrimental to them. Simply, my lord, they could have said.
You're reading something else. They are only escaping from, they don't want to incur any financial liability. That's all. You can't read something more into it. In continuation.
Earlier order stands, my lord.
We'll say it is not in continuance. We will accept their statement. It is not in
Not
continuance.
be set aside, my lord, that order.
That order will set aside.
Yeah. And part of the impugned judgment, my lord, para 1923-24, honorable single judge.
The question is that for setting aside that order, we need to.
No, that part your lordship will expand, my lord, from the impugned judgment. 1923-24, honorable single judge says that it is not stigmatic. That part has to go, my lord.
No, Mr. Talukdar, you're not. Of course, you're understanding, you're going on the right direction. The moment we are inclined to set aside that order and accept this order as a fresh order. But for saying so, for setting it aside, we need to expatiate on facts. We can't say that we are because Mr. Talukdar argued, well, we are setting aside the order. Can we say
One
that?
difficulty is there, my lord, because Lordship kindly appreciate, when I go to a new employer, my lord, I have to give this particular letter, my lord. They have to fresh a new one, my lord, because there are references of earlier letters, my lord.
Your
Dipti Prakash Banerjee, my lord, has-
there. Mr. Pura, you ask you withdraw both the letters, issue a fresh letter. We are not going to question him. To that extent, he deserves it.
Dipti Prakash Banerjee, Lordship, is aware. Supreme Court judgment made it clear.
Next week, come with a letter which does not have any continuance certification. That contract is over. We are not in. The contract stands concluded. There is no further extension. Finished. Issue a fresh letter, and all these letters you withdraw.
In supersession of all the.
Nothing. All these earlier letters are withdrawn. The contracts. Don't mention. If you do that, we will not ask him to even open his mouth. We'll finish. He will not press it. But that also will take it. You have heard Mr. S.K. Talukdar, learned advocate for the appellant, and Mr. D. Bora for response numbers
2 and 3.
2 and 3. The impugn judgment dated 2/4/2026, passed in WPC number so and so, has been questioned by the appellant on the ground that notwithstanding the stigmatic stigmatic termination of contract of the appellant, it did not carry any stigma because it was a closure of the terms of agreement which expired on 31/5/2025. It appears that the appellant was engaged as a finance manager under the Assam Skill Development Mission for the Assam Skill University project, which was funded by Asian Development Bank. The appellant claimed that he was selected through a proper recruitment process against an advertisement, and his selection as a finance manager was confirmed in the year 2022. A contractual agreement was entered into for serving in the project of the mission, in the Assam Skill University project for a period of for a particular period. The contract came to a close on 31/3/2025, but the appellant continued working thereafter. Though the appellant perhaps thought that it was only an extension of his contract. In the meanwhile, the project management unit was transitioned from Assam Skill Development Mission to Assam Skill University. And the university became the implementing agency for the mission. It further appears from the record that a show cause notice had been issued to the appellant, alleging that he had been negligent in submitting the annual expenditure and finance statements to the Asian Development Bank. There was no proper consultation with the technical assistance consultants. The charge against the appellant was denied by him. In fact, it was clarified by the appellant that he had not submitted the annual expenditure and finance statement. Rather, it was submitted by Assam Skill Development Mission after all the approvals for furnishing of such an explanation. For the furnishing of such statement. However, by an order dated page 89, 2/6/2025, the term of contract of the appellant was concluded and he stood relieved from Assam Skill University project. This was questioned by this termination of contract was questioned by the appellant before a learned single judge who concluded that the appellant who concluded that the appellant was under a contractual agreement which stood terminated after 31/5/2025. However, as noted above, the court, the learned single judge, found that there was no material brought on record. Found that there was no material brought on record to indicate that there was any allegation of misconduct against the appellant. The unsatisfactory performance, the learned single judge observed, was noticed for the purposes of relieving the appellant from the post of finance manager. Such dissatisfaction was on the basis of the employer noticing that the appellant had not been diligent enough in ensuring that annual expenditure and finance statement was properly submitted to the Asian Development Bank. The learned single judge went into the charge which the appellant had faced of not being diligent. But because the appointment of the appellant was purely contractual and there was no extension of contract, comma, it was observed that there cannot be a judicial review of a decision not to renew the contract. And that any other way of limiting the services of an employee would be a better option. However, we find that the order dated 2/6/2026, 25 is a stigmatic. Sensing that the earlier order referred to above is stigmatic, the what would go? The chief executive officer of Assam Skill University project has issued a letter dated 8/5/2026 communicating to the appellant that the confirmation of the completion of engagement and a decision not to renew the contract of engagement. It was also clarified in the letter dated 8/5/2026 that no financial liability would be incurred by the Assam Skill University project beyond 30th of June 2025, the date of expiry of the term of contract of the employer. With this letter having been issued by the employer, there cannot be said to be any stigma on the appellant, except for the fact that this letter has been shown to be in continuation of the earlier letter dated 27th of June. Earlier letter dated so and so, they cannot at page 89. Earlier letter so and so. The learned advocate for the respondent number 2 and 3 submits that though this letter has been stated to be in continuance of our earlier letter, but it clarifies that this is only a decision of not extending the tenure of contract with the appellant. We thus hold that the letter dated 8/5/2026 does not bear any stigma so far as the appellant is concerned. With such understanding of the letter dated 8/5/2026, Mr. Talukdar, learned advocate for the appellant, does not press this appeal any further. The termination of contract of the appellant is held to be non-stigma, and the foreclosure of the tenure is purely contractual. The appeal stands dismissed. Why they will issue another letter? We are disclosing it.
Well, that order will say, sir, page 89.
There would be no necessity of keeping the order dated so-and-so on record, which stands recalled by the respondent number 2 and 3 with the issuance of the letter dated so-and-so. The order dated so-and-so is thus set.
We are just about to publish the name of the selected candidate for the finance.
Where is who is he to stop? Who are we to tell you?
Item 16 for hearing.
Highly obliged. Pharmacy Council of India. Pharmacy Council of India state has to tender to nominee. Earlier nomination the term expired. So government in this matter, if you lost it, fine at page 68.
Who appeals for respondent number 6?
I am appealing for response 6.
You have filed your affidavit.
No, sir, I have.
Correct.
I
Yeah.
have already joined, madam.
Okay. Well, you have been selected.
No, sir, I have.
You were perhaps a pharmacist in the assembly with very, what should I say? Lesser qualification than Mr. Saiwala.
Only B pharma.
But your appointment is by all approvals.
Approval. Madam, here, your loss will find, my lord, that by page 68, my lord, when the vacancy occurs, the director of medical education has been asked, my lord, by the joint secretary, government, my lord.
Is 68.
Basically, 3 names are sent. They are all the 3 are highly qualified, my lord. Highly qualified.
No, nobody is questioning that.
No, only my lord, they have to
The
select
issue
one.
here is whether your nomination could have been recalled without any.
My lord, I'm coming to that, my lord. I'm coming to that.
Pass kariye na, ye sab. Why are you unnecessarily dilating on all these
No,
issues?
because
Mr. Sahewala, you are a better qualified person to be on board of the pharmacy council. Correct. Period.
but his name was not there well in the 3 person.
Period.
His name was not.
That we understand.
And the 5
But a
person,
fresh nomination before the selection.
my lord, your lordship,
So,
no, selection was done at page 69. 5 members committee, my lord, 5 committee, my lord. Screening committee. Screening committee has constituted.
But look at, you have to, Mr. Saiwala, if you ask us to look into these facts, then
Yes.
you are perhaps not dealing with the appeal. The question is that the learned single judge holds that the health department has been bifurcated. I mean, there are 2 separate
2
departments.
departments, my lord. I shall come to that also, my lord.
Why, that is the issue now that you question.
No, here what happened, my lord, if you also see.
Mr. Saiwala, try and understand what we are talking to.
Yes.
Now, whether you are good or respondent number 6 is good, that is not a question for us to decide.
Yes.
Now, in all its probability, whatever you have stated in your petition, whatever you stated before the learned single judge, we can infer that you have a better qualification, you were recommended, everything was done.
My lord.
But then suddenly in the last moment, it was recalled by the family welfare department, which ought not to have interfered. Because this is a matter of MERD and not family welfare.
Right.
But the difficulty is that MERD does not question it.
My
Number one.
minister is involved.
One second. MERD does not question it, and then the minister approves of it. Are we to assess?
My lord, your losses.
Our certification will help.
My lord,
Yes,
your,
Mr.
no, my lord, your losses may see.
Mr. Bora, which wing of the health department is to deal with all this?
My lord, that is because initially MERD recommend the appellant, and prior to that, my lord, the health department recommended other, my lord. So subsequently, the recommendation of the MERD has been withdrawn.
Something else. You're again telling us the background fact.
No, my lord, because there is no specific guideline that which department has to recommend. But otherwise, my lord, the functions and other works, my lord, of Pharmacy Council of India, some of are under the MERD, some of are under the health department, my lord. So
This-
ultimately,
On a pharmacy council, a nominated member would be vetted by which wing?
What is the perspective?
that has been done by the health department, my lord.
No, it has been done by family and welfare.
Health and family welfare department.
Health includes MERD also.
No, my lord. Now both are different departments, my lord.
Where is your affidavit?
Affidavit has page, my lord. 196, my lord. We have filed affidavit on behalf of the health department.
Education and research, medical education and research.
Research department and page 196, my lord.
Just give us 1 minute again.
Page 196. Timing, your
1 second.
That, Mr. Saiwala,
My lord.
there is difficulty. Now, there is no opposition by the MERD.
My lord, I'm submitting, my lord. Here, you have also see first, when the letter has been issued, 73, page 73, my lord. No selection. Which happens to subject cited one
Page
dash
73.
73. Page 73.
73. Yes.
My lord, it is issued on 7th of August 23.
Hmm.
I am directed to inform you the following registered pharmacy is hereby nominated so and so. No selection. No selection, my lord. Then the another letter follows, my lord, at page 74, which says that report on this, sir. That is on 29th August.
So this is the.
Page 74.
Hmm.
That says, my lord, that it is issued with the approval of minister.
Nomination of Vijay Kumar.
Yes. Without any selection.
Were you communicated?
My lord,
Were you communicated? Were you told the reason for withdrawal of your nomination?
no, nothing, my lord. Nothing. Nothing.
And Mr. Bora, once you nominate by all process, then when you withdraw the nomination, you have the powers to do so. This interdepartmental encroaching on each other's field, it is not a question which we'll get into it because of no department challenging the other department's, powers. That we will not go. But we might ask you a question that when you are cancelling the nomination of Dr. Vichitra Kumar Dole, you're withdrawing it, then you must tell him, no. Did you communicate it to him? And for what reason?
My lord, kindly come to page 208. Initially, my lord, the Pharmacy Council of India wrote a letter to the Principal Secretary to the Government of Assam in the Health and Family Welfare Department, seeking nomination of a member. The MERD department was never communicated with any letter seeking any nomination, my lord. The Pharmacy Council kindly page 208.
Why then this committee, how and when this committee is constituted? What reference? In a committee.
My lord, that committee, why that has been constituted, by whom it has been constituted, because my lord, the authority to nominate member is government, my lord. And that committee was constituted under the directorate level, my lord. That committee was constituted under the directorate level, my lord. But
You could have very well taken the reason, Mr. Bora, that, of course, the committee was constituted and the committee recommended Mr. Dole, but now, since the Health and Family Welfare Department has been asked for a nomination, we are withdrawing your nomination because it was by
my lord,
MERD.
that committee under whose direction or under what authority that has been constituted or they have recommended, my lord, because the authority to recommend is government, my lord. And that committee was constituted under the directorate level, my lord. That recommendation does not have any value, my lord.
My lord, see page 75 also, my lord.
Why, under what authority, they so moto in their own, my lord, they have constituted the committee and recommended. Who asked them to nominate, my lord? Recommend.
Government letter is there.
It is on the.
What will stand on this in the affidavit? Before the proceeding.
My lord, in our affidavit, we have said that the Register of the Pharmacy Council of India on 23rd June 2023, as page 208, communicated to the Principal Secretary to the Government of Assam in the Health Department to nominate a member because the earlier member, term of the earlier member is expiring, page 208, my lord. So in response to that letter, my lord, page 209, we have nominated the
Kolkata EPP committee constituted by the director.
Well, earlier there was only one department. In 22 only it was bifurcated. That is why they wrote the letter to the.
Any adequate reason? Immediately, after months. Where is the requisition? Pharmacy Council has asked whom? Where is that letter?
Well, that
Page
I have annexed also.
208,
Malad.
Yes, and in my affidavit also it is the next, my lord, page 208, my lord.
I don't. Malad, at the time, Malad, the only one department was there. Earlier it was only one department. That is why Malad was in 2020.
The department was bifurcated when?
Page 75, Malad.
Tell us.
Page 75, it was 5th May 22. Because earlier recommendations were done by the. That is why they wrote the same department. And rules of executive business also say same thing.
No. Department of Executive Business says that in case of dispute, there is no dispute here. Nobody is raising a dispute.
Malad,
It's a matter of time to be the chief secretary or the.
No,
chief of the-
letter is there, Malad. Page 77. Page 77.
No. Please tell us. At page 75, this is the notification from the office of the governor of Assam
Malad.
bifurcating the department.
Malad.
This is of 5th of May 2022.
Malad.
The
Pharmacy, Malad, it comes under
One
medical.
second, sir, Mr. Saiwala, can you hold on for a minute? Now, this Pharmacy Council of India, notwithstanding the bifurcation of the department, on 23rd of June 2023, I mean, makes a requisition to the Health and Family Welfare Department.
Malad, it was earlier one department. Malad. They did not know that.
Earlier department, 5th of May 2022.
22, but at that time, that was not the information. Earlier, Malad, one department was there. Normally, that department was recommending it. So they wrote to them, Malad. It was done by the government of Assam, Malad. Pharmacy Council has no knowledge, Malad.
The government of Assam is cooperating. Let's have withdraw. Withdraw. So therefore, we take this recall of your nomination by the MERD also. Because they are not objecting.
Well, you'll also pay 77, Malad. They have objected, Malad.
They objected.
Yes.
What?
Malad, what they had done. Director of Medical Education wrote a letter, Malad, to the Commissioner and Secretary. Malad, saying that I have honor to inform that Richard Malad, a senior faculty. So, what Malad case is concerned?
And how is the learned single just said that there is no objection, this is the objection.
Yes.
My lord,
And because you are the standing counsel for both the departments.
yes, my lord, the authority to nominate is government, my lord. It is by the director, my lord.
So the correct option here should be the should be referred to the chief secretary. He approves that, so
My lord.
let the matter be given to the chief secretary.
In the MERD department.
No, we are not, Mr. Bharat, try and
Yes,
understand,
madam.
we are not disputing this. It
Yes,
is the
madam.
government's prerogative.
Yes, my lord.
Departments are for convenience.
Yes, my lord.
So health department
My
without
lord,
any
assuming
objection.
that page 78 is a objection.
Let it be decided by
My
the
lord,
chief secretary.
Assuming that 78 is a objection, this objection was.
Section number 6 continues. There
Yes,
is no, we are not interfering with his appointment now.
yes, my lord.
Mr. G. Rahul, you are representing him, no? So you continue, don't be worried. But this matter would be sent to the chief secretary, he will tell us. In case of any dispute, executive business.
Yes.
Otherwise, it makes no sense. We'll come back again.
Much.
The lunch. Any other matter thereafter, because the court has to rise for reference. Any other matter apart from this?
Lordship, if I may, Lordship, in the tax matter 18 to 19, in item number 19, I am being led by senior counsel Mr. K. N. Chaudhary, and we have only recently been engaged, Your Lordship. Therefore, we should not 19 hearing supplementary. Senior counsel is appearing on the other side.
Just a minute. 18 and Pankaj Mazumdar.
We're in 19.
19 Union of India. You, whom are you appearing for?
I am appearing for the appellant in 90. Your lordships were pleased to meet fixed today.
Yes.
I was appearing online on the last day. So I said that if your lordship is kind enough.
Is that Brahmaputra port matter?
No, this is its nearest matter. Brahmaputra is 18. There they have, the Honorable Tribunal has ruled in favor of the board that no, the entitlement is not as a matter of right under the OM of May.
If you have come from outside?
I have come from Delhi.
So we will hear you in case of necessity. If you are not agreeable to the matter being postponed, we will not put you to further trouble. You argue and you go back, you respond from there.
Grateful. Grateful.
Really? We are not able to force advocates from outside to go back without discharging their responsibility. You will respond. Then he will, if he has to rejoin, he will do it online. If he wishes to come, he is most welcome. But we'll not ask him to go without his opening his mouth.
Grateful.
Unless he himself says so. This privilege the counsel from outside has, that if he is here, then we must hear it.
And on the last date of hearing, I was appearing and your lordship was kind enough and they were aware that I would be traveling.
But then because of the absence of Mr. Chaudhary, I mean, many cases have been adjourned. We have adjourned most of the cases. Because,
that is in your lordship's discretion to decide.
No, but still we have a rule of housekeeping.
Considering let's yes,
We have
considering all aspects, your lordship will be
outside
kind.
advocates, because many a times we also were outside advocates in different courts, and it was very frustrating to go there and then hear that the matter has been adjourned.
Lordship is right.
So therefore, if you can manage, it is all right. Take a call. We will reassemble after lunch. And if you think that you will argue, we will not stop you from that. We will give you the opportunity.
Great.
If not, if you want to argue there, we will ensure that on the next date both of them will be there. If you want to argue in his presence, even better, you can take a call. But we will give you that liberty.
We are always in the hands of your lordship.
No, we are giving you this liberty. We are, of course, if we decided that no, we will hear it on one particular day when both the lawyers are there, then we would not have said that. That option is for you. You take a call now, 1 hour, have tea, coffee, and
Great.
The issue here, as we have heard Mr. We have heard Mr. G.L. Saiwala, learned senior advocate for the appellant. Mr. D.P. Pora, standing counsel, health. What is this Ministry of?
MERD, Medical Education and Research Department.
Ministry of Medical Education and Research Department. And Mr. G. Rahul, correspondent number 6. The dispute in the present petition, present appeal, is regarding the nominations as State of Assam's member to the Pharmacy Council of India under Section 3H of the Pharmacy Act 1948. The appellant, who claims himself to be a highly qualified pharmacist, had applied for nomination, which was considered by the screening committee, by a screening committee constituted by the Director of Medical Education. Stop. All eligible applications for nomination were evaluated, whereafter the appellant was recommended for his selection as the nominee of the state for becoming a member to the Pharmacy Council of India. His name was forwarded to the Pharmacy Council of India by the Medical Education and Research Department on 8/8/2023. However, the Health and Family Welfare Department, through its Joint Secretary, bracket respondent number 4, forwarded the name of respondent number 6, a pharmacist working in the Legislative Assembly's Health Center, on 7/8/2023, and later on 29/8/2023, recalled the nomination of the appellant and confirmed the nomination of respondent number 6. This apparently was done with the approval of the Honorable Minister of the Department. Mr. Saiwala, learned senior advocate for the appellant. Mr. Saiwala has drawn the attention of this court to a communication made by on behalf of the Pharmacy Council of India to the Principal Secretary, Health and Family Welfare Department, seeking nomination of a member, a person to be member of the Pharmacy Council of India under Section 3H of the Pharmacy Act of 1948. Pursuant to such requisition / communication, the Joint Secretary to the Government of Assam of the Medical Education and Research Department recommended 3 names, the appellant being one of them, for being considered for nomination. For the purposes of evaluation of the candidature of the aforementioned 3 persons, specific views were sought from the Director of Medical Education, Assam. It appears that a screening committee was constituted by the Director of Medical Education, Assam, for selecting 1 out of 3 candidates who were one out of 3 candidates for becoming a member. The committee comprised 5 persons who, by minutes dated 1/8/2023, found the appellant to be most suitable for being nominated as a member to the Pharmacy Council of India from the Government of Assam. It further appears that simultaneously, the Joint Secretary to the Government of Assam in the Department of Health and Family Welfare recommended respondent number 6 to be a member. And by letter dated 29th of August 2023, recalled the nomination of the appellant, which was made by Medical Education and Research Department's letter dated 8/8/2023. Mr. Saiwala has argued that a proper procedure was adopted by the Medical Education and Research Department for selection of the name of 1 person out of 3 for nomination to the PCI, which could not have been recalled unilaterally. He has further submitted that respondent number 6 could not have been nominated straight away without any procedure being followed in that regard. That apart, it has been submitted that it was only on the communication made by the Pharmacy Council of India that the exercise was initiated for selecting the name of a person who was to be nominated. And it was only after proper scrutiny that the name of the appellant was selected. Responding to his submissions, Mr. D.P. Bora, learned counsel who represents the Health Department, which includes Health and Family Welfare Department and Medical Education and Research Department. That in fact, the requisition was made to the Health Education Department. Was in fact that the requisition was made to Health and Family Welfare Department. And that Medical Education and Research Department ought not to have initiated any exercise for selecting the person and for selecting the person, selecting and forwarding the name of the person to be nominated as member of the PCI. Yeah, PCI बोलते हैं और pharmacy company. We have noticed that on 5th of May 2022, under the orders of the Governor of Assam, a notification was issued in the interest of public service to reorganize the existing Health and Family Welfare Department into two separate departments of Roman 1, Health and Family Welfare Department, and Roman 2, Medical Education and Research Department. The Health and Family Welfare Department had to have the control of the Directorate of Health Services, Directorate of Health and Family Welfare Services, Directorate of Ayush, National Health Mission, Food Safety and Drugs Administration, Assam State AIDS Control Society, and all nursing schools. The Medical Education and Research Department was made the controlling department for Directorate of Medical Education, all medical colleges and hospitals, including dental colleges, nursing colleges, pharmacy, and paramedical institutes under the Directorate of Medical Education, Government of Ayurvedic and Homeopathic Colleges, Assam Cancer Care Foundation, Atal Amrit Abhijan Society, Pradhan Mantri Jan Arogya Yojana, Assam Employees Health Scheme, Assam Health System Strengthening Project Society, Srimanta Sankardev University of Health Sciences, and any other institution relating to medical education and research. It was also clarified by that notification that all correspondences relating to existing Health and Family Welfare Department will now be made in the name of the new departments as per allocation. As per allocation. The requisition from the pharmacy, next paragraph, the requisition from the Pharmacy Act, the requisition from the Pharmacy Council of India for nomination of a member notwithstanding the bifurcation of the department was made to notwithstanding the bifurcation of the department was made to Health and Family Welfare Department, which actually was not allocated the work related to pharmacy and paramedical institutes under the Directorate of Medical Education, of which the controlling department was Medical Education and Research Department. Under such circumstances, it has been argued by Mr. Sayara that Medical Education and Research Department had taken up the exercise of selecting a suitable person for nomination, which could not have been recalled. And a new need of respond number 6 was introduced, who also joined as member of the Pharmacy Council. The issue before the learned single judge, therefore, was as to which department had the authority to nominate. According to the rules of business, the rules of executive business, in case of any dispute regarding the reach and ambit of the area of work, the issue had to be referred to the chief secretary or the chief minister, as the case may be, for resolution. Not doing so and recalling the nomination of the appellant was an abuse of the exercise of power by the Health and Family Welfare Department. The learned single judge did not agree with the submission of the ground that the nomination of respondent number 6 was with the approval of the concerned minister, and that there was no complaint whatsoever from the Medical Education and Research Department regarding the nomination of respondent number 6 later, after the Health and Family Welfare Department had already recommended the appellant. Under such circumstances, the learned single judge concluded that the issue was in the realm of administrative decision, which did not require or necessitated any judicial review. The power of judicial review, the learned single judge concluded, in such matters was very limited, especially when no case of malafide, arbitrariness, or unreasonableness could be amply demonstrated. It was also held that in the event of the nomination having the concurrence of the minister in charge and no complaint made by the department as such for any usurpation of the power by another department, the interference was absolutely unnecessary. Any interference was absolutely unnecessary. However, from the records available, we find that though a general communication was made to the Family Welfare Department by the Pharmacy Council of India. But since the since the pharmacy and paramedical institute, since any matter relating to pharmacy, any decision regarding any matter relating to pharmacy and paramedical institute, pharmacy. What did I say? Was within the control of Medical Education and Research Department. Normally, the Medical Education and Research Department was required to take a decision. True it is that the Medical Education and Research Department did not have any objection to the nomination of respondent number 6 by Health and Family Welfare Department. But in order to settle the dispute, a resolution as to which department has the jurisdiction to process the file for nomination of a member to the Pharmacy Council of India was necessary. We do reckon that the nomination of respondent number 6 by the Health and Family Welfare Department has the approval of the minister in charge. But then it would have been more appropriate if the issue would have been resolved by referring the matter to the chief secretary, referring the matter to the chief minister. Thus, interfering with the order passed by interfering with the judgment of the learned single judge. We direct that the matter should be placed before honorable the chief minister for a resolution of the dispute. Until the time any decision is taken in that regard, respondent number 6, who has already joined as member of the Pharmacy Council of India, shall continue to discharge his function. The appeal stands disposed of.
Item 18 and 19 supplementary list.
You're Mr. Bharadwaj.
I'm Kaushik.
Yeah, I'm talking to you.
I'm Naresh Kaushik.
Naresh Kaushik, yes.
In fact, the name of the advocate on record also is wrongly mentioned. The Wakalatnama has been filed by my learned colleague Seema Dolo. That needs to be reflected in the all list also.
There is that list. List. Yeah, 18, 19, 18.
She is the counsel on record having filed the Wakalatnama.
You are appearing in 19.
19.
And for the appellate is this, you are Mr. D. Panging is the name of the advocate. Okay, you are the appellate. You're the appellate.
Yes. Mr. Apang was appearing for the respondent leads the institute.
Correct. So what decision have you taken? Would you wait for the other counsel to come in item number 18? Or you would, it's always better to have the arguments when both the sides are present.
Lordship is right next. I go down to that next. But since your lordships has expressed in the order passed earlier in this
Oh,
matter,
we have heard this matter.
a prima facie view,
Okay.
I would, let's just
Okay, I don't remember.
seek your lordships to ascertain as to whether my written submissions which we handed over to the bench directly, whether they are on record or not. Written submissions were filed, were handed over when the matter was listed at Itanagar bench. Otherwise, we have spare copies, we can. Just to facilitate your lordships, let's.
Yeah, 1 second, 1 second. Mr. Kaushik, just a minute. Okay, we had on our directions. We have got it listed along with your case.
Yes,
And this is to be heard. This is to be heard, Mr. Kaushik, not like this.
lordship. Do your lordships have on record the written submissions filed by us?
We will check it out. Where? Where is it? This minute. Yes, we have.
Grateful. Could I assist your lordships only with a few points for your
Don't
lordships?
forget, Mr. Kaushik, our memory is not like you advocates who would remember cases for months together.
I have the experience of appearing before my lord in Delhi High Court also. So I have my own opinion about my lord's memory.
It's very kind of you, but it has been 10 years that you've seen. And memory fades, number one. The capacity also lessens with the passage of time. But then we will hear it on that day, whichever date is convenient for you.
18th of this month.
18th of June.
18th of June. 18th of June. If
There would be some difficulty because if you could get another date by the end of June or second week of July after the court reopens.
So 2nd of July, second week of July, Supreme Court opens. So if it could be any date in June, I would be deeply, grateful.
We will. Any problem with that date?
Lordships, 18th and 19th of June, my senior may not be here. He'll be for an outline bench of this one.
21st, 22nd, whichever.
21st, 21st is the Sunday.
23rd is it?
23rd is all right, huh?
23rd.
25th or 24th, no, 23rd, there is.
We can put it on 23rd.
23rd, there is an issue.
22nd, would it be okay? Or 24th, 25th?
24th or 25th, whichever is convenient.
24th. 24th is okay?
No issue.
24th is a Thursday.
No, wait, there's little bit.
25th is okay. So 25th is a better day, no?
Gratefulness. 25th also is fine.
Okay. So 25th.
Grateful.
Let both the matters be listed. 25th of June.
And it's, if,
In that case, we shall not, we will hear.
great, that's grateful. That is all.
We will hear.
I don't
And
want
the
it to
other,
be.
the other lawyer, the other side, whichever side lawyer is not present, they can appear online.
I don't want it to be recorded, but it's my learned friend is here.
I don't record these things because you never know what
That's
happens.
why, that's why.
You know, the bench may not be constituted. I mean, there could be many things.
Lot.
So normally we don't record
Lot.
unless we are in a different, there
Yeah.
is some anger there or something. That is not here.
Everything is not in
Yes.
our hands. There is some power.
Some power is there and the pleasant demeanor of Mr. Kaushik. How do we say no or yes? So we fix it on a date convenient for you.
Deeply obliged.
Listen.
25th.
So we come back at 3:30. There is a reference to it.
Great.